on pandemic unemployment assistance. As we've said in a few of our recent live streams, that really, if you don't have your benefits and haven't had a hearing, the only real way to force ESD to give you a hearing is to have a court order it. And we've talked about something called a writ of mandamus. And so we're going to go through today how you might be able to obtain one. David, do you want to give a little bit more explanation about what a writ of mandamus actually is?
Yes, so writ of mandamus, first of all, it's an extraordinary remedy. So you've got to understand that this is like a Hail Mary. This is a chance for a judge to get involved if you have no adequate remedy at law. If you have been waiting for a hearing and you haven't gotten one, you haven't gotten any word from the Employment Security Division, typically they will issue a denial and have a hearing. And from that hearing, you can do a petition for judicial review. That is an adequate remedy at law. When you don't have any of those rights, when you're sitting in limbo, not getting any feedback from the Employment Security Division, this is what you can do to wake them up. But we can't stress enough that this is a Hail Mary. This is something that you hope a judge who is a politician will take an active interest and move this process along. But oftentimes it's bogged down with procedure, with not understanding how to proceed. I would say most judges in Clark County don't know what a writ of mandamus is and don't know how to deal with it. So that's the hurdle, that's the mountain that you need to climb in this process. So it's an extraordinary remedy. Again, it's not usually done in court. You don't see these very often. So that's why it's difficult, it's discretionary. And this is simply, if you are sitting around having nothing to do, this is something you can do to try to take charge of your situation and make things happen.
All right. So just to kind of start by pointing out where the forms that we created are, you can go to our website, nlslaw.net. It's under the Know Your Rights Work and Employment page. And you'll see the unemployment benefits and then the forms. And we have instructions, the actual writ petition that we'll go through today, and a proposed writ for the judge to sign that you can submit with your petition. Any first thoughts while I pull up the writ petition,
Yes.
David?
Yes. First of all, what you're doing is petitioning, asking the court to get involved. So we call it a petition for writ of certiorari. It doesn't mean the court's going to grant it. It doesn't mean that you're going to get the relief you want. It's just asking the court, petitioning the court for help with your situation with regard to the Employment Security Division and their inability to schedule a hearing and deal with your pandemic unemployment assistance, your PUA application. Now, because we've done this so recently, we only applied it to Washoe County and to Clark County, and only under the situations where you applied for PUA on May 16th, 2020, and haven't received any feedback yet, or received notice that you were denied and you haven't received a hearing yet. Well, okay, concentrate. Again, this is the writ. This is the Clark County writ. We've also created one for Washoe County, and we will soon, hopefully this week, create one for all the other district courts in the state of Nevada.
And just a reminder, if you guys have any questions while we go through this, please feel free to put it in the comments to the video. All right. So as we said on the website, there are accompanying instructions for this, but we are just going to kind of take you through the form and explain kind of how to fill it out and what you need to do with it.
Oh, one other thing. So if you don't want to post a comment or you have a question later, we have a website. It's in the instructions, Ray.
Yes, and I will pull that up when we're done so that everybody has it. Yeah. All right, but we did create just a fillable form. As David said, this is really for a situation where you've been denied and have requested a hearing or filed an appeal and have heard essentially nothing and have not gotten your hearing and have not actually had your hearing. So that is kind of limited in terms of the issues that people are facing. But, this is the kind of the most common delay that, people who have applied for PUA have been experiencing. If you have applied for PUA and haven't actually received a denial notice, please give us a call. But this is, if you have received some sort of notice and you haven't had your hearing and you want to get your hearing so that you can get your benefits, this would be the way to go. So you want to start, and this is just, putting in your name, your address, your phone number, and your email address. And this is similar for the Washoe County petition, which you'll see. So this is just your information so that the court can contact you. Again, putting in your name there, and then we get into the actual writ. As you can see, like I said, it's fillable. So that's why I want to go through this and just kind of point out where you guys need to fill things out.
It's fillable, and just keep in mind, you're the petitioner. You want to use your name as you applied with the Employment Security Division. It may be your full name, whatever it is. Put your name as the same name as your application with the Employment Security Division.
And then this is your ask. What you're seeking is a writ of mandamus, so that the court can compel the Employment Security Division to comply with the laws regarding pandemic unemployment assistance. And these are the statutes and the regulations. And of course, we also reference the due process clause, which we'll talk about. But these are the laws that require the Employment Security Division to have issued you a denial notice, to have issued you your benefits, or to have held a hearing well before now.
And this may be legal mumbo jumbo that people really don't understand. You can't really go to the court and say, give me the benefits. What you're doing here is saying it's taken way too long and the Employment Security Division has to do something. Schedule a hearing, give me a notice. So you're not asking for money, you're asking for a hearing. That's why this is so dumb. They should do this anyway, but this is really what we're asking for in this writ.
All right, and so some of the key facts that you're going to have to put in, and you'll see this multiple times, really to just, as David said, I mean, we're talking about the length of time it's been since you've applied and not gotten your hearing. So the operative facts are going to be dates. So you want to put in the date that you actually applied for PUA, the date that you were denied, and then how long it's been. And this is really just to reinforce that this is ridiculous that you have to do this.
There may be some of you who haven't gotten a denial, so that sentence you could just X out or just not fill in. It's not going to impair your ability to file the writ if you weren't denied.
Yes. Yes, go ahead. If you weren't denied, just, you can cut all that out about the denial. Everything else is fine though. All right, so the next section is the ability of the court to actually issue the relief you're seeking, which is that writ of mandamus to compel ESD to give you a hearing. So it goes through Nevada law regarding writs of mandamus, which David, I don't know if you want to go through that a little bit more.
Sure, this is what I talked about before. It's a discretionary thing. It's a remedy when you don't have any other legal remedy at law. It doesn't really require a hearing. A judge can dismiss it without even considering it. So there's the nature, the laws that I was talking about before in describing the writ. They're set forth in the writ. And this goes, again, to my comment that most judges don't know what a writ is. This explains it to the court, explains it in simple terms that this is something that a judge needs to consider. It's extraordinary relief. And you do this when you have no other remedy at law. So you don't do this every day. It's an extraordinary. And what I say right there is typically there's a denial and you have a petition for judicial review. We haven't gotten that denial. We haven't gotten a hearing. We've gotten nothing.
Right. So, just to explain, this plain, speedy, adequate remedy in the ordinary course of law. Normally what happens is you're denied. You appeal, you have a hearing, and after that hearing, you get a written decision. That written decision can be appealed further. There's an administrative appeal, and then you can actually go to court to appeal that. But because they've not given you your hearing, you have no other remedy but this writ of mandamus.
And this is why it seems so stupid, because if they're arguing fraud, if they're arguing you're not eligible, it all comes out at the hearing. It all is conveyed to the referee so you can make your arguments and do what you need to do. Make a record, create a reason why you're denied or a reason why you're given the benefits.
All right. So some more just background for the court on what a writ of mandamus should do until we get to the actual argument. So this is the issue that you were not granted a hearing and your benefits dispersed in 7 weeks. Let's go ahead and go through the facts, and then we'll explain why the 7-week time limit is so important. Again, as I said, all of the facts that you guys are going to need to enter are dates. So the date you filed, the date you were denied. And again, if you were denied, if you were not denied, then just cross off the parts about appealing because everything else still applies to you. But you put in the date you filed, the date you were denied, and again, the date you appealed, which would be your request for a hearing, and then repeat over and over again how long it's been since you have applied.
You may think, oh, I have to do this again. Well, it's important. If it's 8 months, it's 8 months. It's a crime that it's 8 months. So if you keep repeating 8 months, sooner or later, somebody's going to realize, well, it should be 14 days under federal law, 7 weeks under the Java case. This is 8 months. So, I mean, that's why you repeat it. It is repetitious, but it's there for a reason.
All right. And then we're going to get into the reasons why the writ should issue, which is the legal arguments that we've developed, why the Employment Security Division is in violation of federal law, constitutional law, federal regulations, state law, pretty much everything. Pretty much what you guys need to insert are the facts that give rise to the reasons why the writ should issue. So we talked about the writ, but essentially, we're asking the court to issue a writ because the court has the power to do so, because they have violated, again, these are all the federal statutes, the regulations, and the Constitution that they have violated by not giving you a hearing and not dispersed your benefits timely. So we first start the argument with the CARES Act. So David, do you want to go through the basis of the arguments under the CARES Act?
Sure. I mean, there's two important facts to get out. One is the CARES Act was meant to give people money immediately. No waiting period, no 7-day waiting period, which is a joke now, because the legislation was created in February of 2020, and we're now in 2021, and some people haven't received those quick benefits. But the idea of the CARES Act would be to get people money right away because of the economic burden of the shutdown, and get money in their pockets to pay for rent or buy food. And maybe it was a little bit misguided to give it under the Employment Security Division in the states. We won't get into that. The point is this money, it's important to bring out that the CARES Act was meant to get money to people quickly. There's no waiting period. There's self-certification. That's all part of the CARES Act. And the other thing is that this money would be dispersed the same as regular unemployment. The same laws, the same regulations would apply, including the Java case, which requires disbursement within 7 weeks.
And that's why that 7-week time frame was so important, because of this Java case. And some of you guys might already have heard the Java case, but it essentially said that when looking at unemployment benefits, a 7-week delay violated the time frames essentially in the federal statute. And of course, we are, for most of you, well beyond 7 weeks, but that is sort of the scheme in terms of the time. If you've been waiting more than 7 weeks for a hearing, then you have potential grounds to ask for this writ of mandamus. If you haven't been waiting 7 weeks, you should probably wait.
Here's another thing too. Java was decided in the 70s. And since that time, the Department of Labor has created standards. And the standard in Nevada is 14 days. 85% of their claims must be processed within 14 days. So it got quicker over time. And suddenly, with the pandemic and the CARES Act and PUA, it's not 14 days anymore. It's not 7 weeks. It's a year. And of course, that violates federal law. It violates the Java case, and it isn't legal, but it's allowed to happen.
So we just go into more about the importance of unemployment benefits, as David indicated, the declaration of emergency, the governor's statements regarding the importance of unemployment benefits. And so that's, again, just more legal basis for this. And so we get to now page 7, where, again, you're putting in the date you filed for PUA, you're putting in how long ago that was. You're putting in the date you were denied, and you're putting in, again, how long ago that was. We're just trying to hammer home how unjust this is because of the long delays. Again, how long it's been since you've received, since you've applied and not received your PUA or a hearing. And as David said, again, this is just more law about the when due requirement, which Java said it was 7 weeks. Other courts have found less time, so 14 days, as David said. So that just goes through sort of the statutory requirement to issue benefits as quickly as possible. And that means, before essentially 7 weeks under the Java case. Anything else, David, before we move to due process?
No, look, I think the outer limit is 7 weeks. If a court, I would think that only the Supreme Court could decide it can be longer than that. But 7 months is a lot longer. 8 months, a year is longer than 7 weeks. And that's basically what you're saying. Again, it's redundant, repetitious, but bring that point home. It's not 7 weeks, it's 7 months.
Right. So the other thing that the delay violates, in addition to just the federal law governing the disbursement of the benefits, is constitutional rights. So people have a right to due process, which means that people have a right to written notice giving the reasons why they don't qualify for benefits, as well as a hearing. This is pursuant to the 14th Amendment of the Constitution. There's been a case law about this, Supreme Court case law. These are the two sort of seminal cases, and that's why they're cited, because it says that before your benefits can be denied or terminated, you have to receive written notice and an opportunity to have a hearing. So another thing, as the Ninth Circuit has even gone and said that delay actually ripens into deprivation. And so if it takes a long time, essentially we're getting to the point where you actually have been deprived the longer and longer it takes for you to get your benefits, which gives rise to a constitutional violation. Again, this is where you put in when you applied, and just to hammer that home, how long it's been, why this is a violation of federal law and constitutional principles.
And there's an underlying sort of point here in that everyone acknowledges that you should disperse these benefits. You should hold a hearing within a reasonable amount of time. I mean, you really don't need to make this argument, but we do, that this is so long that you're entitled to this federal benefit. So the federal and state constitutions kick in. And look, we've been waiting so long, they haven't even scheduled a hearing. So this is a deprivation of that federal right. And so that's what this argument is all about. Stated a different way, you're not relying on a statute, you're not relying on regulation, you're relying on the Constitution. And when you get to that fundamental level, you have to ask yourself, how can the state, how can people, politicians in the state, the administrator of the division, how can they allow this to happen? It's unconstitutional, yet it continues to go on.
But that's basically it. That's your argument. Again, finally, just hammering it home how long it's been since you've applied and not gotten your benefits or hold a hearing. And that's it. So as David said, this part here talks about what we're asking for. And you are asking to have your benefits dispersed or for them to hold a hearing. and if you paid costs, seeking reimbursement of your costs. But that's basically it. Then if you're e-filing, you can just type your name in here. If you do end up signing up for an e-filing account in either Clark County or Washoe County, you can then sign this electronically. I would, encourage everybody to do so just for convenience. I will pull up the instructions, but we also do provide a little bit more information on it when you need to mail your petition in. So we will go ahead and address the instructions in just a minute. The final thing on here you'll see is a certificate of mailing. When you file this, you also need to send 2 copies of your petition to the one to the Attorney General's office and one to the Employment Security Division. So you will need to make sure that you have the ability to print or make copies.
Yes, that's important because we've experienced when we do file these writs, sometimes the Deputy Attorney General who's assigned to the Employment Security Division will contact us and schedule a hearing or grant the benefits. So when you are sued, you may not think there's merit or whatever, but if they can get you the relief that you want, you don't really care. And so that's definitely the reason to send it over to the Attorney General's office, because if they know this is going on and they can simply schedule a hearing and get rid of your writ, they're going to do that.
And one other thing, sorry, David, one other thing I just wanted to remind people, there is one question. Sorry, where did that go? All right. This is where you can access the petitions for Clark County and Washoe County. As David said, we will have a form for the rural jurisdictions. So I know there's somebody who is interested in Lyon County that will have a couple more blanks to fill in, but we will have those petitions and hopefully by tomorrow. All right, but as I mentioned, we do also have instructions that go along with this.
Can
It
we
just does.
stop, Ray, that tip?
I'm sorry?
Go up a little because you'll see that tip. Yeah, reality check.
Okay.
I just want to say, filling in these forms, it's maybe a third or half the battle. The other half is getting some judge to look at it. So just realize by doing this, it's not going to be, oh, happy days are here again. No, there's a lot of work. You may have to call the judge. You may have to email the court. So filling out the writ, filing it, that's half the battle.
Right. And as you've suggested, and as one of our commenters have suggested, it might spur them to avoid the cost of further litigation and just take a look at your claim, which is the goal.
Right.
All right, so some of the documents you need, and I'll actually talk about this in more detail a little bit later down. If you're e-filing, the only thing you do not need is well, you do in Clark County. Never mind.
In Clark County, yeah.
Yeah, I forgot about that. I'll stop. Never mind. Forget I said anything.
We'll have another session on the civil cover sheet.
Yeah. So here are the documents that you'll need. This is true in Clark County if you're e-filing or mail filing. You will need a civil cover sheet. You will need a fee waiver form or your fee and a fee disclosure form, and then a petition for writ of mandamus. This is true of Washoe County. If you're mail filing, you will need a civil cover sheet, a fee waiver application, or the fee. There is no fee disclosure form, but then you'll also need your petition. So go ahead.
It's $270. So it could be cost prohibitive. It could prevent you from filing. So if you can't pay the $270, it's less, I think, in Washoe County, but
$255
do that fee waiver because the judge could waive the fee. It's just going to take longer. And that's kind of why I have this maze, because it is a complicated maze that you have to go through.
So we did say we have step-by-step instructions for each page of the petition and where to input the information, but hopefully the information we're asking you to input is not something that, isn't easily understandable. You really are just putting in your name, your information, and then the dates that apply to your case. All right. So filing. So as David said, the Clark County filing fee is $270. It is $255 in Washoe County. You can sign up online for e-filing in both Clark County and Washoe County. We do have the links to the websites where you can do that included in the instructions. David mentioned the fee waiver form. In Clark County, this is where you can go to get the fee waiver form to fill out. If you're e-filing or mail filing, you will want to file this at the same time you file your petition. If you don't, you will have to pay the fee. If you're paying online, you'll need to use a credit card. I believe you have to use a credit card. If you're mail filing, you can send a check. Again, these are the documents you need. You'll need a civil cover sheet, the filing fee with the form, or the application to waive the fee. I've also inserted links here where to get the filing fee remittance form for Clark County. The civil cover sheet and application to waive the filing fee, again, are here. If you mail file, you'll also want to make sure that you include copies. So if you want a copy of any of the documents you send to the court back to you, you have to provide the court those copies and an envelope with postage on it for them to mail it back to you. So just make sure, if you want copies in your mail filing, you have to provide those copies to the clerk's office. If you're e-filing, you have access to your case. You can get the documents that are e-filed anytime you want. So both Washoe County and Clark County have case search essentially functions where you can look to make sure if your case has been filed. If you mail file, that information will still be online. It just won't be you won't have access to an e-filing system. All right. Go ahead.
That's a good sort of helpful tip is when you see that it's been assigned to a particular department, if you go to the 8th Judicial District Court, you'll see the judge, you'll see a picture of the judge, a biography of the judge, along with the law clerk's phone number. So you don't want to harass, but you do want to contact the law clerk and figure out if the judge is going to have a briefing schedule, how the judge is going to handle the writ, and that's some of the follow-up that you'll need.
Right, because it's unclear what the judge, once you file it, as David said, that's just the first step. It might be unclear what the judge is actually going to do. We've actually created one final form. I'll actually pull it up now.
Yeah, you should.
And that's the order on the actual writ of mandamus. So this is something that you will want to submit to the court after you file your petition, and that's essentially a proposed order granting your writ of mandamus. So this is also available on the website, and again, you just fill in your name here, the case number and department number once that is assigned by the clerk's office, and then the rest is left blank, and this would be for the court to fill out. So you can submit this, right after you file your petition or with your petition, I guess. Depending on how you want to do it. But this is just basically a proposed order for the judge to sign. But it's up to the judge what he wants to do. So essentially, these are the three options that the judge might take.
And keep in mind, under Nevada law, when you file this, the court can't simply grant your writ, although some judges do. The judge can either deny the writ or set a briefing schedule and hold the hearing. Now, as I tried to explain in the instructions, you've already made your argument, so you shouldn't be too scared by a briefing schedule. It just requires the AG's office to respond and provide any arguments against what you're saying. And that's really what the order, if you call the court and the clerk says, yeah, give me an order, you would have to email that form to the clerk, and the clerk would fill it out, the dates and what's necessary in terms of service and what the AG, what the Employment Security Division has to do.
And as David mentioned, the final thing we'll say is, as you're going through this process, if you have any technical questions, you can email us at PUA Writ Now. And we will try to provide information as you go along. Please be aware, we cannot give you any legal advice through this email. If you want further assistance, you need to go online to our website. I'll pull that up again. And you can submit an online intake by clicking this link right here. We cannot give you legal advice until you go through our intake system. If you've tried and unfortunately you do not qualify for our assistance, you can also call the Nevada Bar Lawyer Referral Service to see if there's a private attorney that might be able to assist you.
And I would say, a good question would be, the clerk wants an order submitted. How do I do that? So there's Administrative Order 20-17 that gives the email addresses for all the courts in which you would submit that writ. You would email it to them and they would fill it out. So that would be like a procedural question. That would be easy to answer. And that's something we can sort of help you with. But if you're saying, do I have a claim? Aren't I eligible for the benefits? Are they paying me? They're paying me $5,000 and I should get $6,000. Those involve complicated legal advice, and you really need to complete an intake if you want further assistance.
Right. All right. So there is one issue I would like to address in the comments. If you have an attorney, please do not take any actions with respect to your case without speaking to your attorney first. This is designed for people who do not have an attorney, do not qualify for our services, or just want to do this on their own. If you already have an attorney, please make sure that before you take any actions on your case, you speak with your attorney first to determine whether or not the attorney is, already working on it, essentially.
And that's
especially if it's Nevada Legal Services.
Right.
Call your attorney.
Right. No, but that sort of confirms my earlier point that this is when you have no other option and you want to just get something done. If you have an attorney, you have options. So this is when you have gotten no response and you just want to do something to take charge of your situation and not just sit there waiting for them to contact you.
All right, but that pretty much does it in terms of going through the writ petition and the process. Again, if you guys have any questions that you think we can answer right now, please put that in the comments. It looks like we're getting some questions, so let me take 1 second, David, if there's anything else that you want to address.
No, let's answer those questions.
Okay, so if a writ is approved, this is what it looks like, essentially, or what it could look like. It basically says that the court orders that petitioners.
There's going to be a hearing.
Oh, sorry. This is to get a hearing. I apologize. So this is to get a hearing on the writ of mandamus. Once the court actually issues the writ of mandamus, it will compel ESD to grant a hearing. Essentially, that's basically what it will say.
Right. That's the relief you're seeking. If the judge goes beyond that, it's on the judge's own discretion. But what we're seeking here is simply a hearing.
Right.
A hearing. Like you can't. It's so insignificant that you'd think, why we have to go through all this trouble, but it is a lot of trouble.
And yes, there's another comment about even if the court orders a hearing and ESD does not follow the court's order, what is the remedy to that? Yes.
Right. Judge Breslow ordered a lot of things and ESD violated each and every one of them. $1,000, that was the fine. So there's no incentive for them to follow any order from any judge, but what can we do? We're lawyers. This is all we can do.
I mean, this is all you can do. I mean, there's really no other avenue. If the court issues an order compelling them to give you a hearing,
Right.
I certainly would hope, ask for a time frame, ask them for a date certain when that hearing should be held by. And if they don't follow it, they are in contempt of court. You can file a motion to hold them in contempt, but that's going to be a messy, otherwise serious process.
But if that happens to you, contact us right away.
Yeah.
If a judge orders a hearing and ESD doesn't comply, they're in contempt of the court's order. So you can do a motion to find them in contempt. And yes, it happened before and nothing really happened, but we would love to take a case like that. That's simply unreasonable. It's irresponsible. It's something that we should pursue and that lawyers should pursue. You shouldn't do this on your own.
And it is unfortunate that that is the state of affairs.
Right, exactly. That if any lawyer was working for the state of Nevada, they would say, look what happened before, $1,000 fine. You don't have to hold a hearing. Just pay the fine. Sorry.
No, I mean, we appreciate that we are providing a helpful service to you guys. We continue to hope to do so, but believe me, our level of frustration cannot meet yours, but it is there.
It's close, right?
But as David said, we're lawyers. We have, these are the legal options that you have, that we have, that we are working in. So we're trying to give you as much information as possible to get relief, I guess.
Yeah.
All right. Well, thank you guys. We do have that email address. I'll go ahead and put that back up. And as always, if you guys have other questions, we will stay on for another minute or so. Go ahead and post those in the comments.
Right.
I'm sorry?
No, I was just going to say, hang in there. There's a stimulus package in Washington. That's going to be helpful. Benefits end, PUA ends March 14th. So we're hoping that there's a continuation and it's done soon enough so that ESD can get their act together and disperse them. There might be some help on the state level, or don't hold your breath. There is some reason to hope at this point, but not much.
All righty then. Well, thank you, David.
Thank you, Ray.
And yeah, well, email the email address if you guys are in this process and need some assistance. Complete an online intake that you can access through our website if you believe you qualify for our assistance. And yeah, good luck to all of you. But that'll do it for today. Thank you guys so much and have a good rest of your day.